Finally, we've just been released from illegal, unjust, unwarranted, and inhuman detention by the Bola Tinubu regime, orchestrated by his illegal IGP, Kayode Egbetokun. And we are heading home, hopefully. In fact, I was supposed to be heading to Lagos for a protest for tomorrow. But we are still checking on the flight, if there's any flight tonight.
Have you seen the warning from the Lagos State government?
They can warn themselves, they can't warn me. You can't warn me about my rights.
Yes.
They are the ones who have to warn themselves about their responsibilities. So it wasn't going to stop me. It is not the first time people who are paid to protect have become very likely irresponsible and warning people not to exercise their rights. So you can't warn me.
Hello everyone and welcome back to Naija Gist Gang, your trusted source for verified updates and balanced insight into the most important stories shaping Nigeria today. I'm your host, Precious, and it's great to have you here today. In today's report, we turn our attention to Abuja, where activist Omoyele Sowore, Aloy Ejimako, and 11 other members of the Free Nnamdi Kanu movement have been released from Kuje prison. Their release follows a week of legal tension after they were charged with inciting public disturbance and disobeying court orders restricting protests in key government areas. Although bail had been granted by the magistrate court, reports surfaced that security operatives briefly rearrested Sowore moments after the ruling, sparking outrage among his legal team and supporters. Upon regaining freedom, Sowore vowed to continue peaceful demonstrations, insisting that his right to protest remain non-negotiable. Meanwhile, in a separate but related development, Nnamdi Kanu, leader of the indigenous people of Biafra, appeared in court where he dismissed his legal team and chose to represent himself. Kanu declared that the charges against him lacked legal foundation and urged the court to either dismiss the case or grant him bail. Legal analysts, including Dr. Ruben Abati of Arise News, have described Kanu's move as a high-risk legal strategy, noting that while he retains the right to self-representation, it may complicate an already complex trial. Both cases continue to raise important questions about constitutional rights, the rule of law, and the boundaries of peaceful protest in Nigeria. Stay with us as we bring you more details, including key reactions from court proceedings and expert legal commentary. Here is the clip from Arise News with more on today's developments.
All right, good morning to you viewers. Let's begin what's trending in the Federal Capital Territory, Abuja, where activists Omoyele Sowore, Aloy Ejimako, and 11 other Free Nnamdi Kanu protesters were released from Kuje prison on Monday. Sowore and the protesters were charged by the police for inciting public disturbance and disobeying court orders barring them from participating in protests at key government locations. The magistrate court had granted bail to the defendants last week and ordered them to present two sureties, each in the sum of 500,000 naira. However, moments after the bail ruling, security operatives reportedly bundled Sowore into a van, prompting outrage from his lawyers and supporters who accused the police of violating the court's order. Sowore, after his release, vowed to continue the protest.
Finally, we've just been released from illegal, unjust, unwarranted, and inhuman detention by the Bola Tinubu regime, orchestrated by his illegal IGP, Kayode Egbetokun. And we are heading home, hopefully. In fact, I was supposed to be heading to Lagos for a protest for tomorrow. But we are still checking on the flight, if there's any flight tonight.
Have you seen the warning from the Lagos State government?
They can warn themselves, they can't warn me. You can't warn me about my rights.
Yes.
They are the ones who have to warn themselves about their responsibilities. So it wasn't going to stop me. It is not the first time people who are paid to protect have become very likely irresponsible and warning people not to exercise their rights. So you can't warn me.
Their release brings temporary closure to their detention, though they still face charges of inciting public disturbance and must return for trial, raising ongoing questions about the limits of protest rights in Nigeria. Well, meanwhile, the leader of the indigenous peoples of Biafra, Nnamdi Kanu, on Monday refused to open his defense in the terrorism case filed against him by the federal government. While during the court proceedings, Kanu, who dismissed his legal team and chose to represent himself, told the court he found no legal basis for the charges after reviewing his case file. Well, Kanu argued that he should not be required to enter any defense for charges and urged the court to release him or grant him bail. Well, here's a video moment of the IPOB leader in court.
Okay, where's the lying news agency of Nigeria? Are they here? Those liars and deceivers, are they here? That distort the news. You don't know what law is. You don't know what justice is. Where's news agents of Nigeria? What are they? You don't know that God is a God of justice. You don't know that? That God in heaven is a God of justice. You don't know that?
All right, Dr. Bati, I mean, talking about this whole court process, this dramatic shift in strategy from listing 23 high-profile witnesses to refusing to mount any defense at all, legal experts argue that it represents a high-risk legal gamble by challenging the very legal foundation of the charges rather than contesting the facts. Well, Kanu essentially asked the court to dismiss the case entirely. Dr. Bati, your thoughts on both stories?
First, let's look at some of the details. Before now, Nnamdi Kanu and his counsel, they had entered a plea of no case objection before the Court of Justice, James Omotosho, the trial judge. And the court said he had a case to answer. In other words, that no case submission was dismissed. And it was on the basis of that that the court now said he and his lawyers should enter the defense. The prosecution, having provided evidence and completed his presentation. Now, when they appeared in court again, Nnamdi Kanu said he was sacking his lawyers in open court. It is a prerogative of the accused person to say, well, I don't want to use these lawyers again. Upon which he then decided to defend himself. It is also within his right to say that he would defend himself. But having talked about 23 witnesses, he has now turned around to say what you refer to as high-risk gamble, that he had no defense to enter because he didn't think that there was any case in the matter. However, it is high risk because, one, he doesn't understand the legal issues involved. He has no legal experience. He doesn't know what the precedents are. So that's why the lawyers you quoted said it's a gamble. How is he going to defend himself? But he has other options to him, available to him. The court of law is a court of justice for the accused person and also for the state. And in that regard, the options available to Nnamdi Kanu now, one, he can say, well, he has heard what the prosecution has said, but he thinks he has no case. That will now be for the court to determine. However, the court being the court of justice is also going to weigh the evidence because the court will not just say, oh, because you say there is no case. The court has a duty to weigh the evidence provided by the prosecution because the scale of justice, has to be balanced. And it's after that they may then ask him, that's Nnamdi Kanu, to enter a written address to respond to the allegations, to the evidence by the prosecution. Maybe he has the skill to even understand, what the prosecution is saying. And then after that, the court will now weigh in all the evidence as fairly as it can to ensure justice, now give a ruling. Now, after the judgment, the option that is also available to Nnamdi Kanu is that he can go on appeal. So the matter has not been resolved yet. Very quickly, as for Sowore and the 13 others. One, the right of assembly is guaranteed under Section 40 of the Constitution. And Sowore and the 13 others, they said they were having a peaceful protest. And there's no evidence that they engaged in any act of violence. They were arrested in the court of law on the grounds of unlawful assembly and causing public disturbance. That has not yet been proven. They also have the right to protest and the right of expression under Section 39 of the Constitution. Now they've been given very stringent conditions. 500,000 bail, you must bring your NIN, you must submit your international passport. But we just hope that justice will be done. The only objection that I see here is with the counsel to Nnamdi Kanu, Aloy Ejimako, who decided to jump into the arena as an officer in the Temple of Justice. That's a resort to self-help on the part of counsel. But that's a matter, that can be considered at another level. But counsel should not descend into the arena and resort to self-help. It's a court of law that is the workshop of lawyers, not to carry banner on the streets.
All right.
The developments in Abuja this week have once again brought to the fore the ongoing debate over the right to protest, the limit of state authority, and the delicate balance between national security and civil freedoms in Nigeria. Activist Omoyele Sowore, Aloy Ejimako, and 11 others were released from Kuje prison after spending days in custody over charges of inciting public disturbance and violating court orders related to the Free Nnamdi Kanu protest. Their bail conditions, granted by a magistrate court last week, included 2 sureties each and a bond of 500,000 naira. However, Controversy arose immediately after the ruling when security operatives reportedly rearrested Sowore moments after he was granted bail, an act that drew strong criticism from civil society groups, legal practitioners, and rights advocates. The incident was widely seen as a breach of judicial process and a concerning example of executive overreach. Sowore, following his eventual release, described his detention as illegal and unjust and vowed to continue peaceful protests in defense of civil liberties. Meanwhile, in a separate but equally significant courtroom drama, Nnamdi Kanu, leader of the indigenous people of Biafra, IPOB, took a surprising turn in his ongoing terrorism trial by dismissing his legal team and opting to represent himself. Kanu told the court that after reviewing his case file, he found no legal basis for the charges against him and therefore refused to open any defense. He further requested that the court either dismiss the case entirely or grant him bail. Legal experts, including Arise News analyst Dr. Ruben Abati, described the move as a high-risk legal strategy, arguing that while the Constitution allows a defendant to self-represent, the complexity of a terrorism case makes such a decision potentially detrimental. Abati noted that the court will still be required to weigh the evidence presented by the prosecution and ensure that justice is done, not only for the accused but also for the state. At the core of both cases lies a broader national conversation, one that questions how Nigeria defines and protects freedom of expression, peaceful assembly, and the rule of law. For Sowore and the other protesters, their arrest and subsequent release raised pressing concerns about how far authorities are willing to go in limiting civic demonstrations. Section 39 of Nigeria's constitution guarantees freedom of expression, while Section 40 protects the right to peaceful assembly and association. Yet, as this incident reveals, these constitutional safeguards are often challenged in practice, particularly when the protests are perceived as politically sensitive. For Nnamdi Kanu, his decision to challenge the legal foundation of the charges rather than the evidence itself signals a shift in his approach, one that may test the resilience and the impartiality of Nigeria's judicial system. His case remains a litmus test for how the courts handle politically charged prosecutions, especially in matters touching on national unity and security. These two developments, though distinct, are deeply interconnected. They both reflect the tension between dissent and authority, between the right to question power and the state's responsibilities to maintain order. The outcomes of these proceedings could set important precedents for how future protest-related cases are handled, and more importantly, how citizens view their right to speak and assemble freely within a democratic framework. As Nigerians, it is essential that we continue to engage thoughtfully with these issues, not from the lens of partisanship, but from a shared commitment to justice, fairness, and accountability. Our democracy can only strive when both the government and the governed respect the rule of law and uphold the constitutional rights that bind us together as a nation. Ultimately, the question remains: can Nigeria build a democratic culture where protest is seen not as rebellion, but as an expression of civic duty? The answer would depend on the actions of all stakeholders, from policymakers and law enforcement agencies to the judiciary and the citizens themselves. At Naija Gist Gang, we will continue to follow these developments closely, bringing you factual, balanced, and well-researched updates as they unfold. If you found today's discussion informative, please share your thoughts in the comment section below. Don't forget to subscribe, like, and turn on notifications so you never miss an update on the stories shaping our nation's future. Thank you for watching. I'm Precious, and this is Naija Gist Gang. Stay informed, stay engaged, and I'll see you in the next one.